There we go. Good morning, everybody. Welcome to the First District Court of Appeals. We have several cases on our docket this morning. Two will be argued. The first to be argued is OTR Housing Associates versus Board of Revisions. Mr. Barrett is here on behalf of the appellant, Mr. DiMuzio on behalf of appellee. Mr. Barrett, you will have 15 minutes to argue. Would you like to reserve any time this morning for rebuttal?
Yes, Your Honor. I'd like to reserve 5 minutes, please.
All right, and then whenever you're ready, you may begin.
Thank you. May it please the court, C. Francis Barrett and Joshua L. Good, attorneys for appellants, OTR Housing Associates Limited and Western Southern Life Insurance Company. And this case pertains to the real estate tax valuation of the project known as Brackett Village, which is a low-income housing project, provides affordable housing for low-income residents and over the Rhine. The date in question is January 1. The tax valuation date in question is January 1, 2017, 2017, tax year 2017. And this is not a profit-making venture. Western Southern formed OTR Housing Associates Limited at the request of the city to provide high-quality, affordable housing in over the Rhine. The prior tax year, 2016, the value was set at $1,794,240, basically $1.8 million. The value was increased for the tax year 2017 to $4,027,370. And again, there's absolutely nothing in the record that supports that valuation. There's no explanation as to how it was increased that much or why it was increased that much. As a result, the process is to go through the complaint process with the Board of Revision, and we did that. OTR Housing Associates filed the appropriate complaint as a Western and Southern for the properties, all of the multiple parcels. And the property was independently appraised by Mr. Eric Gardner. He valued the property $1,060,000. The owner testified that there are 105 units. The fair market value is about $10,000 per unit, which gives us a value of $1,050,000. The hearing went before the Board of Revision. The staff appraiser for the county auditor's office, Mr. Jeff Neiman, essentially agreed with the valuations advanced by the property owner's representative and by the property owner's independent state certified general real estate appraiser, Mr. Gardner. The Board of Revision reduced the value to $1,275,000. The school board offered no witnesses or no testimony or no evidence in front of the Board of Revision, but indicated that the school board would be appealing to the Ohio Board of Tax Appeals. We appealed to the Common Pleas Court first to prevent the case from being heard in the Board of Tax Appeals. And again, it's not really relevant, but my experience in the past has been the Common Pleas Court is more objective than the Board of Tax Appeals. So since we did not get the full reduction we sought, we appealed to the Court of Common Pleas. After we appealed the Court of Common Pleas, unbeknownst to us, the school board filed a notice of appeal with the Board of Tax Appeals. Again, unbeknownst to us, this process was moving along. We were never notified. Then I received a notice that there's a hearing in front of the Board of Tax Appeals on the school board's appeal. So I filed a motion to dismiss that. And although the school board objected, the Board of Tax Appeals dismissed the appeal. So we go back to the Common Pleas Court, and the school board then filed what they called a notice of second appeal beyond the 30 days. And there was a skirmish in the Common Pleas Court over whether that was permissible or not. The magistrate, first of all, ruled it was permissible, contrary to Ohio law. The trial judge then ruled it was not permissible to file the notice of second appeal in the Common Pleas Court, but the record from the Board of Tax, the appeal filed in the Board of Tax Appeals was basically proper and could be transferred to the Common Pleas Court, which again is not proper. So then we go to the hearing on the merits, and the school board requested the right to present additional evidence to hire an independent appraiser to form an opinion of fair market value and submit an appraisal report. That never happened. The school board only hired Mr. James Burke to do an appraisal review. All he did was comment on the appraisal report of Mr. Gardner. He never commented on the appraisal report of Mr. Jerry Fletcher, who was the second appraiser that we retained, because the school board questioned the methodology used by Mr. Gardner. Mr. Fletcher independently appraised the property, and his opinion of fair market value was at $1 million. He used the income approach. He explained, as did Mr. Gardner, why the construction, the cost approach is not appropriate because it's not new construction and it's not appropriate for a subsidized project. The sales comparison approach or market approach, sales comparison approach also was given a little weight, and everybody agreed that the proper approach is the income approach. The appraisers all testified, the two appraisers for our side, no appraiser for the other side, testified that the proper methodology is to determine what would be the fair market value. In other words, what would the property sell for on the open market, doing a market analysis. Our appraisers did a market analysis, and they concluded that the rents, the income, are reflective of market conditions. The actual rents are reflective of market conditions. That's because over time, the quality of housing in Over the Rhine has gone up. So even though we have subsidized rents, those rents are reflective of market conditions. The same with the expenses. The expenses are consistent with market actual market conditions. There was no question as to the expenses themselves. The appraisers testified the expenses are in line with what they should be. There were no excessive expenses. Expenses are reasonable and necessary to maintain this project. So what we have is a situation where the rule of law is that low-income housing tax credit projects, government subsidized projects, are not supposed to be appraised based on the actual rents and expenses when those are not typical of market conditions. In other words, if you have rent subsidies from the government, those can increase the income, and it's not fair to do that for an open market analysis, what property will sell for on the open market. Same with the expenses. If you have mortgage guarantees that might reduce the expenses, again, that is not appropriate, because if you reduce the expenses, that would increase the fair market value unfairly. The appraisers all confirmed that the expenses were consistent with actual market conditions, and there was no evidence from anybody suggesting the expenses could in any way be reduced. So we had a situation where the evidence from all the people expressing opinions of value was very, very consistent. The owner at $1 million, Mr. Gardner at $1,060,000. Excuse me, the owner was at $1,050,000. Mr. Gardner was at $1,060,000. Mr. Fletcher, whose appraisal report was never challenged by anybody, there was no appraisal review of his report, had a fair market value of $1 million even. Now, the school board argued that because the appraisers used actual rents and actual expenses, their appraisal reports had no value, and the magistrate adopted that argument, which is again contrary to law, because the purpose of the law is to protect the property owner. The law on not using subsidized rents or mortgage guarantees on the expense side is to protect the property owner from having a project which is valued for more than it would sell for on the open market. So all the evidence as to what the property would sell for on the open market was consistent. So after the magistrate, for whatever reason, increased the property back to over $4 million, objections were filed with the trial judge. There's a whole series of issues with that process. But notwithstanding that, the trial judge made some significant mistakes. For example, he referred to the fact that there were competing appraisals. There were no competing appraisals. The school board never hired an appraiser to do an appraisal of the property. He never formed an opinion of fair market value. He specifically stated he had no opinion of fair market value. Furthermore, he did no analysis on the fact that this was a low-income housing tax credit project. So,
Mr. Baird, can I interrupt you? Can I interrupt you and ask a question? Cutting through everything, is your argument that the actual rent, the subsidized rent, and the actual expenses in this case reflect the market rent, the market revenue, and the market expenses?
Yes, Your Honor, that's exactly our point.
All right.
We believe that.
Mr. Baird, let me ask you a question. It looks like the actual expenses for this project are high. And I don't necessarily see that as a negative, in that, at least in my mind, it means that the property is well maintained by the owners. Can you address the fact that these expenses seem high relative to other low-income housing projects in the city that have been compared?
This is a very well-maintained project. The Sandra Smith, who is the manager, testified how well it's maintained. It's clean, it's safe, it's secure. It's very important. Walnut Street has had a number of problems in terms of crime, and this is the safest project on Walnut Street. The appraisers both testified that all the expenses are necessary to maintain the quality of this project. I mean, if you want to cut the expenses and have an inferior project which is not maintained, that can be done, but that's not, again, reflective of fair market value. In other words, if someone was going to buy this property and pay top dollar for it, they would want a property that was well maintained. Those expenses are necessary to maintain this property in first-class fashion to provide quality living for low-income housing residents in Over the Rhine.
You have 1 minute left if you'd like to reserve 5.
I will. I'll take 1 minute to explain. Basically, we believe the evidence is essentially uncontroverted, that the appraisers used a market analysis, and the court should adopt the values established by the appraisers in the range of $1 million to $1,050,000 or $60,000. Secondly, the alternative is to adopt the valuation established by the Board of Revision of $2.75 million. That is the default valuation, and we would accept that, even though it's higher than our appraisals. That would be proper for the court to accept, because on appeal, the Board of Education never made it met its burden of proof to set aside that value adopted by the Board of Revision, which again is minimally plausible under the standard to be accepted. Thirdly, if the court can't accept that, we would ask for a new trial for on the reasons we asked for all the irregularities that took place with the trial judge. But we don't believe we need to get that far. We believe the court should accept either alternative A or alternative B. Thank you very much.
All right. Thank you, Mr. Barrett. You are at your time. You'll have 5 minutes for rebuttal. Mr.
Thank you.
DeMuzio, you have 15 minutes.
Thank you, Your Honor. May it please the court. My name is Dave DeMuzio. I'm the attorney for the school district. This is a relatively simple case. The appellants had the burden of proof all along. They filed the appeal with the Common Pleas Court. They didn't need to do that, but they did that. And obviously at the Common Pleas Court, they had the burden of proof to prove their value. They presented 2 appraisals that were deeply, deeply flawed. So deeply flawed that they violated dictates of the Ohio Supreme Court. The question that Judge Myers asked earlier is very interesting, and the answer is very, very interesting that Mr. Barrett gave. He said, yes, my case basically is that in this case, the actual expenses are the market expenses. The problem with that is that his own experts said that's not true. There is zero evidence to support that particular position. Mr. Gardner, their initial expert on page 55 of his report, talks about the market expenses and indicates that he freely admits, he calls the comps he used a peer, P-E-E-R. So he tried to find comparables that were similar, kinds of comparables. We see this every day in real estate cases. You can have situations where they pay high salaries. Mr. Gardner indicates on page 55 of his report that he looked at and felt that the staff salaries were higher here. So we don't know what's going on. You don't know if they're overpaying people. But market value is about what someone else would pay for it. Someone who would maintain it perhaps differently, perhaps more economically. And therefore, it could be worth more to that person.
Mr. DeMuzio, if I could interrupt you.
Sure.
From my reading of the various case law, it appears that the reason it needs to be market rent is so that it is not atypical of the market due to government subsidies. Can you address that, please?
Yes. Again, Mr. Gardner
and I'm
indicated.
talking about the expenses, not the
Right.
rent.
Right. Mr. Gardner explains in detail in his report what his expense comps were, what he felt the market was for what he calls peer properties. And there he admits they're roughly half of what he comes up with. And he doesn't, when he's asked to explain why they're different, he says, well, the salaries are higher, the repairs are high. Why? That's what it's all about. If you're always going to just defer because somebody says they're necessary, nobody thinks what they do is a bad job. But the Supreme Court clearly said in a number of cases that we cite that the best approach is to use market of similar properties, because that takes out all the other factors. If you can find similar properties that are operated more efficiently, then you have to assume that's what the typical market purchaser would do. I would say this: there's zero evidence in the record concerning Mr. Barrett's assertions, which relate to your question in his reply brief about the Columbus City case. He cites the Columbus City case as interesting. He talks about how sometimes you can use actual expenses, but what they're talking there is, as you mentioned, are there special situations that are special to these kinds of properties that would warrant that? No evidence put on by his experts on that. In fact, as I mentioned, they were careful to use comps that were very similar. This Columbus City case, the concern there was that if you use market expenses of non-subsidized properties, then yes, you can see the problem with that. But here it appears that Mr. Gardner went ahead and used comparables of similar properties. So that takes out that issue.
Mr. Muzio, let me ask you a question on that, on the expense end. If someone were to purchase this housing project on the open market, wouldn't it be important to them to know what the actual expenses are when determining what they were willing to pay for that property?
Certainly, they want to know what they are. But again, we have that in every case, not just subsidized expense case. We see all kinds of situations. And the Supreme Court has time and time again said you must use market. If you don't use market, then you get a situation where somebody can inflate their own expenses. Keep in mind, these people are subject to taxation. So if they show large profits, they pay more in taxes. And their mission really is to provide low-income housing, not to make a big profit. And so you can see how these are difficult to value. But the Supreme Court has done, I think, an excellent job of explaining the ground rules, and they just don't meet. It was obvious to us. If you look at my closing in the magistrate's hearing, we were well aware of this Bedford rule that Mr. Barrett's talked about. The reason Bedford doesn't apply here, the reason it's okay to use the old auditor's value, is that Mr. Barrett did not present competent evidence. I use the word competent evidence in my closing. So we were very aware of it. We were aware that we had that burden of showing that it wasn't competent. Whether it's competent or not, judges, is a question of fact for the Common Pleas Court. This is not something that the Court of Appeals should change absent an abuse of discretion. These were very, very deeply flawed appraisals. We had.
Mr. Muzio, let me ask you a question. So what evidence is there in the record that supports the auditor's valuation of $4 million plus for this property, keeping in mind what the auditor's representative, Mr. Niehaus, said at the Board of Revision?
Yeah, you have to understand the Board of Revision, there is no discovery. It's not what you would call a fair fight. So you want to be very careful about relying upon anything that's said or done at that level. Mr. Barrett knows what he's going to present. He comes in, he presents it. We have no ability to get discovery to see if his appraisers are good or bad. And the auditor sometimes has a week or two, if that much, to look at what's been presented. The auditor didn't do their own analysis on that. There's also zero evidence supporting the 1.7 million that it had in its prior valuation. That appears to be way low. So whether that's way low or the 4 million's way high, that's Mr. Barrett's obligation. He's clearly 100% under the law has the burden to show that $4 million is wrong. He didn't do that. He came in with deeply flawed evidence, tried to get something. If you've ever seen these properties, they're very, very nice. They're the ones that you see there on Walnut Street as you head down towards 13th. They look like New York townhouses, like New York row houses. They're very, very, very nice. And to say they're worth $1 million, I mean, on its face, it simply has no credibility. This issue about no conflicting evidence, the best kind of evidence is an admission against interest. When you can use the other side's appraisers to admit that, yes, Mr. DiMuzio, we did not rely upon market rents. And yes, Mr. DiMuzio, market expenses are roughly half of what of what this particular one had. That's golden. That's the best kind of evidence. You can't get stronger evidence than that. Secondly, we did have Mr. Burt testify. We did hire an expert, and he just tore apart the other appraisers. And we have to assume that played a large role in the Common Pleas Court's decision to say this wasn't competent evidence. And thirdly, and most importantly, because I knew that I would be attacked on this Bedford, I was careful to get Mr. Gardner to testify about what would happen if the proper numbers were used. What would happen if the Supreme Court's dictates were followed and market expenses were used rather than actuals? And he did testify to that. It's in our brief. The judge, for reasons I disagreed with, or the magistrate, decided not to adopt that. But I think it was $3,191,285. So we got, Mr. Barrett can't have it both ways. He can't sit there and say, Mr. Gardner is this great appraiser, and then say, but we should ignore his $3,192,000 if we plug in the right numbers. That's really all we did. We just plugged in the right numbers, corrected the mistakes. And so I think the court could come down with that number. I didn't think the judge had a good basis for saying what she said, the magistrate, on that one. And that's certainly a backup. That's the lowest it should possibly go. There is evidence by an expert supporting that number. There is no evidence, no probative evidence supporting any of the numbers that Mr. Barrett is suggesting that we use. If you have a personal injury case and you have an expert appear for the plaintiff, and the personal injury expert admits that it was really the plaintiff's fault that this accident occurred, that's evidence. That's very strong evidence. That's the sort of thing that happened here. We were able to utilize his experts to, basically make our case. I can't think of a stronger kind of case. And there was therefore no need for us to have our own appraiser. We had that option, and we chose instead to simply utilize the attack that we did. We cite the case in the brief where the Supreme Court has said that's a perfectly appropriate approach to take. So there's tons and tons of evidence. This is an abuse of discretion case. This court, in order to reverse, would have to decide that both the magistrate and the common pleas judge abuse their discretion in rejecting these two deeply flawed appraisals. And I just don't see any way that can be upheld. That's all I had. Thank you.
Thank you. Mr. Barrett, you have 5 minutes remaining.
Thank you, Your Honor. Just like to clarify a couple of points. First of all, at the Board of Revision, we are required to submit our evidence in advance. The school board had our evidence in advance, namely the documentation from the property owner, manager, also the appraisal report prepared by Mr. Gardner. They had that in advance, as did the auditor's office. The auditor's office is actually required to base its values on appraisals, and the auditor's staff appraiser, Mr. Jeff Neiman, concurred with our evidence. So the auditor abandoned its valuation. The auditor's staff appraiser abandoned its valuation. The auditor's representative on the Board of Revision abandoned that $4 million valuation. And as we're in court right now today, the auditor's office and the Board of Revision have decided not to participate, which is extremely rare, which is indicative of the fact that they do not support the valuation established by the auditor. And there is no evidence in support of that valuation of $4 million. The hypothetical questions that Mr. DiMuzio asked, which the magistrate properly did not allow, was questions: if you assume these are the income numbers, and if you assume that these are the expense numbers, wouldn't this value result? And those were hypothetical, speculative numbers. There was no basis for those numbers that he used to cross-examine Mr. Gardner, and hence there was no justification for anybody to accept that, including the magistrate herself. But more importantly, both appraisers indicated that the expenses are necessary to maintain this project. No one has suggested any way to cut the expenses. If you actually cut the expenses, it reduces the value of your property if you don't maintain it in the proper way. So to cut the expenses, when these expenses are necessary to maintain the project, would be a self-defeating act. And again, the standard is the Board of Revision decision will stand if there's some competent evidence, which is minimally plausible. And in this case, you have the auditor's representative on the board concurring with that. You have the staff appraiser concurring. You have two independent appraisers concurring. The school board represented to the court that it wanted to hire an appraiser to form an opinion of fair market value to do an appraisal. Mr. Burt never appraised the property, even though he had the right to do so. He never formed an opinion of fair market value. He never offered any evidence of fair market value. And more significantly, he never questioned the accuracy of the income, never questioned the accuracy of the expenses. The hypotheticals about the expenses, again, are misleading, because what you have to do if you're a prospective purchaser, you have to look at what you could actually afford to pay and what it will cost to maintain the project. And again, the evidence is from the property manager, from the owner's representative, from both appraisers. This project is only well maintained. The expenses are necessary and justifiable, and nothing should be cut. So you basically have a situation where there is no evidence from the Board of Education at all, no evidence of value to refute the evidence we presented. No evidence from the Board of Education is sufficient to overcome the valuation established by the Board of Revision, and the Board of Education does have that burden of proof on appeal, and offered nothing in support of that position it took. And furthermore, the case law says that an appraisal review is not competent evidence for the Board of Education to meet its burden of proof. So therefore, we submit that the position taken by the Board of Education is without merit. I'm happy to answer any questions that any of the members of the court may have.
Thank you. Does the panel have any questions?
I don't.
Council, thank you both very much for your arguments this morning. We will take this case under submission and give you a timely opinion.
Thank you very much.
Thank you.
Thank you. And Ms. Hayden, if you will bring in our next parties and counsel. Good morning. The next case on our docket this morning is State versus Ojale and Mr. Alawali. And am I pronouncing your name correctly, sir?
Yes, Your Honor.
All right. And did I pronounce your client's name correctly?
Yes.
Thank you. Ms. Steyer is here on behalf of the state of Ohio. Counsel, you will have 15 minutes to argue this morning. Would you like to reserve any of that 15 minutes for rebuttal?
Yes, 5 minutes for rebuttal, please. All
right. Whenever you're ready, you may begin.
Thank you. As you're aware, my name is Emmanuel Halawali, 0079154 for the appellant. We're here this morning about the trial court's decision denying appellant's motion for a new trial and a motion for a new trial and a motion for leave to file a motion for a new trial. This case is more about looking into the merits of the motion that he has been trying to file. Well, he filed his first motion on August 15, 2011. That was the time that the court could have ruled on the first motion. The court never ruled on it. The state did not respond to the motion. The court ignored that motion. Over the years, Mr. Ojale filed other successive motions, which the court denied. Then, 9 years later, they still hadn't ruled on his first motion for new trial that he filed timely. At that time, he amended the motion to include new evidence because during the pending of this case, two of the witnesses who testified in this case have come forward to recant their testimonies. And if you look at the merits of those convictions, without the testimonies of these people, he wouldn't have been convicted in the first place. So we're not looking at a situation where the trial court ignored ruling on a motion. We're looking at a situation where, but for some of this evidence, he wouldn't have been convicted. This is a man that is serving 22-year sentence. He could have been out of prison or not be in prison in the first place if the court had ruled on this motion when they needed to be ruled on. The court eventually denied the motion just last year in 2020. And at that time, it was a form of a generic denial. The court denies the motion, citing that all pending motions are denied. There is no reasoning behind the denial. There is no legal or factual ground behind those denials. Now, let's look at some of the merits that Mr. Ojale is talking about. When it comes to the June 15, 2020 motion that he filed a motion for new trial, for leave to file a motion for a new trial. At that time, the court gave the state 2 extensions to file a rebuttal. The state never responded. Nevertheless, the court denied the motion. This is a situation where if the state and the appellant are put on the same level ground, an appellant filed a motion, the state did not respond. The state had 2 extensions. Nevertheless, the court denied the motion. So we're asking this court to overrule the court's denial of the motion for new trial and the motion for leave for a new trial, because the court abused its discretion in doing that. Now, we have when it comes to the second ground for this appeal, the second ground for this appeal is based on the fact that Mr. Ojile filed a new motion for leave to file a motion for new trial based on newly discovered evidence. And I will break down the discovered evidence that he's talking about. First of all, he was acquitted of one of the counts. We came before this court about 7 years ago, and this court agreed that the court should have given him a hearing when he had new evidence. And at that time, too, we're able to show that his trial counsel was deficient in his performance in representing him. That is one of the evidence that he didn't have at the time of his conviction. And apart from that, he also had 2 affidavits from one co-defendant and one jail witness. One of the defendants is Kenyatta Erkins. He had no control over when he was able to get this affidavit. The second one was from a witness, Taron Tanks, who at the time was the state witness. He was in jail with him at the time, and he claimed that Mr.
Counsel, if I
Ojile.
could interrupt for a second, the affidavit from Tanks appears to have been signed more than a year before the motion was filed. Can you please, there's case law that says that there shouldn't be that long of a delay. Can you please address that?
Yes, the reason Mr. Ojile waited that long before he eventually filed it with the court was that at that time, he thought he had a pending motion because he filed the motion in 2018 that the court ruled on within 2 weeks. But nevertheless, the court did not serve him a copy of that judgment entry. So he thought that motion was still pending. So he was waiting for the court to at least set a hearing. And when they set that hearing, he was going to present that affidavit as part of that motion. So he didn't even discover that the court had ruled on it until later on. So when he eventually discovered that, he had to file a new motion for leave. And at that time, he also had a new affidavit to support the one from Tanks. So we're talking about a man who is incarcerated. He had no control over the witnesses. He had no control over his own time. In fact, he had no control even over his own body because he's under state supervision. He's under state incarceration. So we're putting a burden upon him that the state itself is not meeting because the state failed to respond to any of the motions he has filed in the past. Nevertheless, the trial court rewarded the state for non-responsiveness by either also ignoring the motion or denying them without even looking at the merits of this case. If they look at the merits of this case, none of these convictions would stand. First of all, let's look at even the affidavits. The affidavit itself exonerates him of those convictions. And if you look at the other issues he brought up, which is his Sixth Amendment right to confrontation of the witnesses, we have a situation where 2 of the defendants testified through a deposition. There's no strategic reason why his trial counsel should have agreed to that because he did not have he wasn't able to, even though he was able to cross-examine them during that time, but he still violated his right to confrontation of the witnesses. The judge wasn't present at the deposition. The judge wasn't there to be able to look at those witnesses, judge their credibility, their body language, even to ask follow-up questions. In a normal trial, a judge can ask a witness to elaborate. The judge did not do that in this case. The only reason they had those trial by deposition was for the convenience of the judge, the prosecutor, and the defense counsel in this case, who was so ineffective in representing his client that we have even proven to this court that he did not even follow up on an alibi witness. So we have a situation where Mr. Ojile has been prejudiced by ineffective assistance of counsel, where he wasn't given his right to confront the witnesses, his Sixth Amendment right was violated, and we have a system where the prosecutor and the defense counsel allowed, where the trial court allowed the case to proceed when the witnesses were available. The witnesses were not sick. The witnesses were not in a situation where we don't have a situation where, even a situation where we have a pandemic, we're still not having trial by depositions. We're talking about years ago when there was no pandemic, the witnesses were available. In fact, they came to the court during trial. There was no reason why they allowed those witnesses to testify by either video hookup or by deposition. So if the court will look at the merits of this case, look at the timeliness and the chronology of the case, and when these motions were filed, it is clear that the trial court abused its discretion when, first of all, it never ruled on the initial motion. And at the time that it didn't rule on the initial motion, it opened the door for the appellant to file a successive motion to amend that motion. And since he amended the motion, the court had the court should have looked at the motion, look at the merits, and decide on the merits instead of just dismissing the case without looking at the merits of this case. This is not about procedure. This is not about convenience. If it is about justice, I think the court should at least look at the merits of the argument. Otherwise, an innocent man will continue to be incarcerated while we're looking at procedures. In order
Mr.
to serve justice.
Mr. Olawale, you are at your time if you'd like to reserve 5 minutes.
Thank you.
Thank you. Ms. Steyer, you have 15 minutes.
Morning, Your Honor. May it please the court. I don't have a whole lot to add to what I've written in my brief. I will touch on a couple of things that were raised during argument. As to your question, Judge Bach, with respect to the timing of the Tanks affidavit and when it was filed, as far as whether or not they held on to the affidavit to wait because they were waiting for another ruling, the two of those are two separate issues. Clearly, if he believed he had another basis upon which to base a motion for a new trial, he should have filed it timely. There's reasons for our procedure. In this case is a lot about procedure. And the reason is because we have to look at also the prejudice to the state as far as motions for new trial that are filed way beyond the time limits that are allowed for in the rule. The state has, the state gets a chance to put on its witnesses, and all these years later, when we're waiting as new trial, motions for new trial are filed, we're also burdened by the inability to bring our witnesses back. As far as the state not responding, that doesn't, whether or not we responded to motions doesn't really affect what happened with them. The trial court ruled on them sub silentio for sure with respect to the August 15th, 2011. That motion was filed pro se by Mr. Ogile before he was sentenced after the bench trial. And what it was after the bench trial, but before the sentencing occurred. It brought up issues that were raised that happened during trial. It didn't raise any new evidence. And so the trial court, obviously by sentencing Mr. Ogile, overruled his motion for that. And there's two separate things going on here. So with those motions, with respect to the August 11th, and then his attempt to amend it in March 2020, all of the issues that were raised in the January motion are moot, or they're decided by law of the case. So only the real issue that's at issue now is the confrontation and whether or not the witnesses testifying by video or by deposition, whether or not Mr. Ogile's confrontation rights were violated. And there's no proof that his confrontation rights were violated. He was there during the depositions. He was also there when the witness testified by video deposition. Whether or not the judge was there during the deposition, that doesn't really affect Mr. Ogile's confrontation rights. The judge was available to rule on any objections that happened during the deposition. That commonly happens when witnesses testify by deposition. And as also I pointed out in my brief, he has not shown that he was prejudiced by any alleged ineffectiveness on part of his counsel by not objecting to the witnesses testifying in person. It seems to be his arguments seems to be, well, then they wouldn't have testified at all. And if they hadn't testified, then the state couldn't have proved its case. But clearly that's not the case. If for some reason counsel had objected to these witnesses testifying either by video or by deposition, most likely there would have been a continuance, the witnesses would have been brought in, and they still would have testified the same as they did in the deposition. So he simply can't show any prejudice. And with respect to the second assignment of error, I've already touched on Tanks's affidavit. Erkin's affidavit was also late. They knew that his second affidavit wasn't late. It was signed, I think, on December 19th or December 2019, but it just rehashed what had already been in his affidavit back in 2013. It just added a little bit more detail. And as far as the acquittal for count 3, that wasn't newly discovered because he knew about it back in 2017 and he was acquitted of it in April 2018. So he was well aware of the effect of the alibi witness in count 3 of the other case. So unless the court has any questions, I'll just submit it on my brief. Thank you.
Questions from the panel? Mr. Wally, you have 5 minutes remaining.
Oh, thank you, Anna. The state claims that the state is prejudiced will be prejudiced if the merit of this case, if the trial court consider the merit of this case, the state is not going to be prejudiced because the state has more power over even the body of the defendants and the witnesses. And when the state argued that sentencing by the court sentencing Mr. Gillett, they implicitly overruled its initial motion. That is incorrect. The court ought to have journalized the entry and affirmatively addressed that motion. The trial court ignored the motion. Sentencing does not obviate the court's duty to rule on a pending motion. And then we have the argument about the law of the case. The trial court never addressed the issues or the merits of Mr. Ojihle's filings or motions. In fact, most of the motions that Mr. Ojihle filed, the court looked at those motions as irritants. If you're really trying to make sure there is justice and an innocent person is incarcerated, trial court should at least look at merits of cases. It only takes maybe a 15, 20-minute hearing or even reading the brief to ensure that. In this case, the trial court did not do that. Prejudice is clear to Mr. Ojihle because if you look at the merits of this case, if you look at the merits of the affidavits, we're talking about a co-defendant who at the time was tried together with him. You couldn't call that person as a witness at trial because they were co-defendants. Years after, this person is coming forward to say, me and this man never robbed this person. So what that means is that he was never there. And we already have proven to this court in one of the counts that it was in New York at the time of the crime. And on the count it was convicted with the other defendant, Mr. Erkins. The theory was that the people that robbed the first guy are the one that also robbed him. So nevertheless, we have proven that it wasn't part of that robbery. And the co-defendant provided an affidavit saying that it wasn't there. So the court has not addressed the merit of that claim. And we also have Mr. Tanks, who came forward to say that he lied when he testified that Mr. Ojihle confessed to him. So what we are looking at is a trial court and the prosecutor's office that is holding Mr. Ojihle to a standard that they are not holding themselves to. The trial court can ignore motions, not rule on motions for years and get away with it. The state can decide to just avoid or not respond to any motions and still prevail. We're asking the court to redress that. It is not fair. They're not on a level playing ground. All we're asking the court to do is to look at the merit of Mr. Ojihle's claim. and ask this court to overturn the trial court's denial of Mr. Ojule's initial motion and his second motion for leave to amend, and at least look at the merits of those claims. Thank you.
Thank you very much. Counsel, thank you both for your arguments this morning. We will take the case under submission and give you a timely written opinion.
Thank you.
And that will conclude arguments this morning for the First District Court of Appeals. Have a good day.
You too.